Hello, my name is Michelle Williams, and I'm an attorney with Wilner O'Reilly Immigration Lawyers. Our firm provides pro bono services to the Veterans Legal Institute, a nonprofit organization that offers pro bono legal services to at-risk, low-income, and disabled veterans. Today, I'm going to talk to you about how you can petition your spouse to become a lawful permanent resident. But before we begin, I just want to add a disclaimer that this is just for general information purposes and does not constitute legal advice. There are two ways a veteran can apply for their spouse to become a lawful permanent resident. The first is called adjustment of status, and the second is called consular processing. If one can adjust status, they can apply for their residency without leaving the United States. But if they are not eligible to adjust status, they'll need to apply at a consulate abroad. I will discuss each process individually, so let's get started. Option 1, adjustment of status through marriage to a U.S. citizen. As mentioned previously, adjustment of status is a process in which a person can become a lawful permanent resident, also known as a green card holder, without having to leave the United States. The general process for adjustment of status is as follows. First, you have to get married. Second, you have to file forms and supporting documentation. And third, you have to attend the interview. To be eligible to adjust status, your spouse will need to meet the following requirements. They would have to have been inspected and are currently in the United States. They would have to have no disqualifying factors such as criminal convictions or previous orders of removal. If your spouse has any of these, then I recommend that you seek the advice of an immigration attorney. And you have to have proof that your marriage is bona fide. If all the requirements are met, then you, as a U.S. citizen spouse, will need to file what's called an I-130 petition. Now, because you are a U.S. citizen and considered an immediate relative, a visa is already available for your spouse, and you can file the I-485 adjustment application at the same time you file the I-130 petition. The forms that you will be submitting are the I-130 petition, the I-485 application for permanent residency, the I-130A supplemental information on the beneficiary, which is your spouse, the I-131 travel document. This is if you want your spouse to travel or if your spouse wants to travel. The I-864 affidavit of support, the I-765 work authorization, and the I-693 medical examination. This must be completed by a doctor. You can get these forms directly from the United States Citizenship and Immigration Services website. I'm not going to go through each form in detail, but I will touch on the most important ones. The I-130 petition is the form that is filed by you, the U.S. citizen spouse. What you need to prove when you file an I-130 petition is that your marriage is bona fide and it's valid, and you're not doing this just for immigration purposes only. What this means is you can't get married solely to get your spouse their green card. You have the burden to prove that your marriage is valid and legitimate. You can prove this through the use of evidence such as documents showing shared finances like shared bank statements and other items, proof of residency that you're living in the same location as your spouse, shared utility bills, birth certificates of any children you have together, affidavits attesting to your relationship, and pictures of both of you and your spouse, and even images of your wedding. The I-485 is the application for residency and will focus on your spouse. On this form, you'll need to include background information about your spouse, and your spouse will need to answer questions about their history. The I-864 is a document you need to submit to show that you can financially sponsor your spouse. You need to show that your annual income meets the federal poverty guidelines based on the number of household members in your home. If you need to make more, you must find a co-sponsor. Other forms. Your spouse will be eligible to work while their application is pending. You must file the Form I-765 application to receive this authorization. Suppose your spouse needs to leave the United States while their application is pending. In that case, you'll need to file the I-131 before they leave, or you will risk abandoning your applications. Once the applications are filed with their appropriate filing fees, you will receive notification that USCIS has received all your application. You will also receive notification that your spouse needs to submit I-693 medical examination. A doctor must complete this form. The next step is the interview. Once all the forms have been properly submitted, you will receive an interview notice. The notice will request that you appear at your nearest United States Citizenship and Immigration Services branch office. You will need to attend the interview with your spouse and be prepared to answer questions about your relationship. Your spouse will need to answer questions about their criminal history and prior immigration history. If everything clears, then your spouse will receive their green card in the mail. If you and your spouse have been married for less than 2 years, your spouse will receive what is called a conditional residence green card. This means that in 2 years, you will have to file an I-751 to remove these conditions. Your attorney or the officer will give you more information if this pertains to your case. Now, if your spouse cannot meet the requirements for adjustment of status, they'll need to complete the process abroad at their nearest consulate. Option 2, consular processing through marriage to a United States citizen. Consular processing is similar to the adjustment of status process regarding the evidence you need to show. The difference is that you'll need to file the I-130 petition and wait till it's approved. Once the I-130 petition is approved, then your spouse can apply for a visa to come to the United States as a lawful permanent resident. Once the I-130 petition is approved, you will receive a letter from the National Visa Center saying that your spouse can now apply for their visa. When you receive this letter, you need to follow the directions carefully. The letter will request that you file the DS-260 application through their online portal, and you also need to submit any of the supporting documents as we discussed in the adjustment of status process. Once everything is submitted, you will receive notice that the consulate is ready to schedule your interview. Your spouse will then attend an interview at the consulate in their home country. Your spouse must show no disqualifying factors such as criminal convictions or immigration violations. If all goes well, your spouse will receive their visa and they'll be able to enter the United States, where they will wait to receive their green card through the mail. As you can see, immigration law can be very complex. If you're a veteran, I advise that you reach out for help if you're going to undergo this process. You may reach out to organizations such as Veterans Legal Institute to be able to help walk you through this process. If you are an attorney who's interested in offering pro bono services to our veterans, then please contact the Veterans Legal Institute at www.vetslegal.org.